now to the most difficult case that we do in this class, which is Regents of University of California versus Bakke in 1978. Right off the bat, I want you to know that there is absolutely no majority opinion of the court in this case. There doesn't exist one. Justice Powell writes the judgment of the court. And the reason why he writes the judgment of the court is that there are two different coalitions on two different questions that Justice Powell happens to be in both of those coalitions. But there's no clear majority in the case. There's a majority in one issue, and there's a very different majority in another issue, except that Justice Powell is the only individual who's in both of those majorities, and so Justice Powell writes the judgment of the court. And the judgment of the court is binding in this case, but it also, and because this is something we would totally want, doesn't provide a lot of guidance in terms of what is constitutional and unconstitutional moving forward with regard to affirmative action. Because this is very clearly an area where you don't want a lot of guidance from the court, and you want things to be completely up in the air. That's exactly how Bakke leaves it. The result is that this decision is very confusing and provides very little guidance to governments, higher education institutions, anyone who might choose to use affirmative action type policies going forward. So here's the background for the case. The University of California, Davis Medical School had a 2-track admission policy for accepting its class of 100 students. 84 of the students were accepted solely on merit. The most qualified people got those 84 seats, or so should I say the top 84 qualified people got those seats. The remaining 16 seats would come from disadvantaged minority groups. So let me provide you a hypothetical. If you were let's say it says disadvantaged minority groups, and they meant all disadvantaged minority groups. It's a very broad brushstroke. So let's just use African American as an example. Let's say you were an African American who was exceedingly qualified. You would be admitted among those 84 students who are admitted on merit alone. But after those 84 seats were filled with the most qualified candidates, the 16 remaining seats would come from the most qualified candidates exclusively from disadvantaged minority groups. So Bakke in this case was a white male who was not accepted into the University of California Davis Medical School. And he sued, claiming that there was, in essence, this rule engaged in reverse discrimination. He argued that he had higher credentials than any of the 16 minority candidates who were accepted on the minority track, and thus he was discriminated on the basis of his race from being admitted into the medical school. Is that clear to everyone? I want to make sure everyone's got the factual background of what's going on. All right, so Title VI of the Civil Rights Act deals exclusively with discrimination in terms of education. It looks very familiar to Title VII, which deals with employment. So Title VI of the Civil Rights Act is what's going to inform this discussion. So any case or law or rule that discriminates on the basis of a racial classification has to be reviewed using the strict scrutiny standard. This is also known as the suspect classification. And the reason why it is suspect is because racial classifications are suspect under the law. It's an exceedingly large hurdle for states to get over. And so in order to demonstrate, hello? All right, who's talking? Mute yourself. or I'll come find you. All right, I'm coming to find you. Gotcha. All right. So the strict scrutiny standard is an exceedingly high bar to pass, but you can get over it. In order to survive the strict scrutiny standard, a racial classification must, one, have a strong, compelling interest or purpose, and two, the means used are the only conceivable and necessary way to achieve that compelling objective. So, you can make distinctions on the basis of race for the purposes of one, a strong, compelling interest, and two, if the means you use are the only conceivable and necessary way to achieve that compelling interest identified. This case uses that strict scrutiny standard to evaluate the rules employed by the University of California, Davis. Yeah, I can repeat the standard. It's known as the strict scrutiny standard. And the strict scrutiny standard says that racial classifications, because they are suspect, have to meet these two different qualifiers. First, there has to be a strong, compelling interest or purpose. So the reason for the racial classification has to be compelling. Like there has to be a very clear and convincing purpose for the racial classification. Two, the means used are the only conceivable and necessary way to actually achieve that compelling interest. So not only do you have to have a compelling interest, you have to use the most narrowly tailored method to accomplish that compelling interest. And so the question is, one, whether the state, or in this case, whether the school's compelling interest of increasing African American doctors or increasing diversity in the medical school is a compelling interest, and two, if the method by which they did admissions, being that 84 go to the most qualified and 16 go to disadvantaged minorities, if that is the most narrowly tailored way to achieve the stated objective. Does that make sense to everybody? Dumb question. If there is strict scrutiny, are there other types of scrutiny? Absolutely. So at this time, actually in 1978, okay. In 1978, there were, I will say, 2.5 different types of scrutiny tests. The first, the lowest, is what is known as the rational basis test. And these are for laws that discriminate on the basis of certain characteristics that do not have a history of discrimination. Height, all of those things that like rules that discriminate, like you can have to be this tall to ride said ride. There's not a history of discrimination on the basis of height, or at least legal based discrimination on the basis of height. So the rational basis test, which simply says that the government has to have or the entity has to have a rational reason for this distinction, is a really low barrier to meet. Most governments can meet that. The rational based distinction is fine. For purposes of race, we have the strict scrutiny standard. So if we think of rational basis standard at the bottom, the strict scrutiny standard is way up here. It's as high as you can get. But that's a pretty wide area. So what happens around this time, and we'll see it in the next section that we do, is the court invents a second standard in the middle, or a third standard in the middle. And that third standard applies exclusively to discrimination on the basis of gender. So there exists other types of scrutiny. We call that intermediate scrutiny. And instead of going into a discussion of it now, I'll save that for when we get into the areas of gender-based discrimination. Because while rational basis and strict scrutiny are locked in place, intermediate scrutiny standard, depending on who's writing it, might look a heck of a lot like strict scrutiny or might look a lot more like rational basis. So just foreshadowing where we'll end up in the next section. I will note that this is the first time, this case is the first time that the strict scrutiny standard was used for a non-minority. So it's not that almost in our entire history of the court, the strict scrutiny standard had always applied to laws that discriminate on the basis of race, racial minorities. This is the first time it's used for a non-minority. And so this case checks off that box as being a first. So what does the state of California claim? It argues that its purposes, the reason why it made this standard, are exceedingly compelling. First, they want to reduce the historic deficit of minorities in the medical profession. Pretty compelling. Two, they want to counter the effects of societal discrimination. Also fairly compelling. Three, they want to improve the delivery of medical services to minority neighborhoods which are currently underserved. Okay, hard way to, can't really, that one's a pretty good one as well. And then fourth, they want to create a diversity in the student body. So they don't just have one argument why they have a compelling interest, they have four why they feel that they have a compelling interest. And some of them are pretty compelling. The court goes so far as to say that yes, these are compelling interests. We can't deny it, that those all are compelling interests in the state. In this case, the university has a really good reason for wanting to make a distinction on this level. However, the method by which they attempt to accomplish those goals are insufficient to survive strict scrutiny, because they are not the only conceivable manner of achieving these compelling governmental interests. The two-track system that they employed was essentially a quota system, which excludes certain people from admission in the class, no matter what their qualifications are. And so that quota-based system does not survive the strict scrutiny standard. Justice Powell, the author of the judgment of the court, has been, not in the cases that we don't cover, you would see that he's consistently been against quotas. He thinks that quotas are sort of a blunt tool. I would liken it to like using a hammer to put a screw in. Like, yeah, you're gonna accomplish the task, but you could have done it a lot better another way. That's how Justice Powell feels about quotas. He's absolutely in favor of taking into account in some broader ways racial identity, but quotas for him run afoul of the 14th Amendment. And so that's why he's the one who straddles both majorities in this case, because he certainly believes that there can be methods that can be drawn up that will take into account race and ethnicity for those compelling interests, but the system that was used here, very specifically a quota-based system, will always run afoul of the 14th Amendment in his mind. So as a result, the court holds that this two-track system violates equal protection, and therefore they can't use the system that they currently have in place. But they absolutely can use race in terms of making decisions on admission. So race isn't irrelevant. They very clearly say that's a compelling interest. You can do that. You can't do it this way. But they don't provide a lot of guidance in terms of what are useful ways to actually use it. They say, no, quote is bad. But they don't provide any sort of ideas about how you would use those systems. So, to put it all together, what the Supreme Court is functionally saying in its decision is that it's absolutely okay to classify by race behind closed doors when the admissions committee is meeting. But making a specific system which makes those qualifications based on race overt and open is a violation, at least in this regard. Without giving a guiding standard, what they basically said was, as long as your rules aren't public, that's all right.